Chapter 5. Nature of the change effected by the Code by the abolition of the forms of actions. Sec. 23. Nature and effect of the change in the abolition of the forms of common law actions. It is essential to study the effect of the Code provision which abolished the distinction between the forms of action previously existing. The nature of the statute, its meaning and effect cannot be perceived without considering it in the light of the common law. For our consideration we select the provision of the Ohio Code which is a common type. The distinction between actions at law and suits in equity, and the forms of all such actions and suits, heretofore existing, are abolished, and in their place there shall be, hereafter, but one form of action, which shall be called a civil action. It has now been simplified so as to read as follows. There shall be but one form of action, to be known as a civil action. The requirement does not affect any substantive right or liability, legal or equitable. The latter part of the section was added in the codification of 1910. It adds nothing to its meaning as it has been interpreted from the beginning as having no effect upon the substantive law of rights. The report of the commissioners accompanying the Code of 1851 specially stated that the civil action did not take original sec. 3. The place of or supplant the extraordinary or other special statutory proceedings. On the contrary, it was specially stated to be the purpose that these should continue as they were where they were not expressly modified or abolished. The report did not undertake to name all of the accepted cases, though it did name habeas corpus and proceedings to assess damages for private property taken by corporations. In general, it was stated that the remedies accepted from the civil action included all statutory remedies and proceedings not theretofore obtained by an ordinary action. Again, it was specially stated that the proposed civil action only takes the place of actions at law and suits in equity. This was designed then to embrace within the meaning of the new action to be created nothing more than debt, covenant, assumpsit, trespass, case, trava, detenue plevin and ejectment, and all equitable remedies. This left out of consideration the extraordinary remedies, mandamus, quo warranto, precedendo, habeas corpus, and the statutory remedies of dower, divorce, partition and proceedings by an administrator to sell real estate to pay debts. All of these extraordinary and statutory remedies, however, were distinctly and separately provided for in other parts of the Code. The reform sought to be inaugurated was with sole reference to pleading and practice in law and equity. No doubt it may be true that the discussions by the codifying commissioners in their report to the legislature had much weight with the courts in the early interpretation of the Code. It would seem to be an impractical question whether the extraordinary remedies and special statutory actions were treated as a civil action within this new provision, or not. It might upon first thought be deemed of interest only from the historical point of view. But in operating under the new Code, practical problems were soon presented. Questions arose whether appeals may be taken from judgments in the cases of extraordinary remedies and statutory proceedings. The statute providing for appeals stipulated that they could only be taken in civil actions in which the right or trial by jury did not exist. In the practice in the common law and equity, appeals were only taken in the latter cases, while law cases could only be reviewed on error by the higher courts. When a case is taken up on appeal, the case is tried de novo, while a case tried upon error is decided upon the record made in the lower court. It is apparent, therefore, that what cases were to be considered as within the meaning of the new civil action became an important one from the practical point of view. One of the first questions which arose in the practice under the new Code of Procedure was whether the statutory proceeding of partition was embraced within the meaning of the term civil action and hence appealable under the statute authorizing appeals, which conferred the right of appeal only in civil actions. It was the opinion of the court that a petition for partition under the statute was never recognized either as an action at law or a suit in equity, and that it was not therefore a civil action under the Code of Civil Procedure, the distinction between which and a civil action was said to have been everywhere recognized by the Code. But partition was always a subject of equity jurisdiction, especially where the case involved the settlement of questions peculiarly cognizable in courts of equity. The special statutory method of obtaining partition is said to have never been exclusive of that in equity under the Code. 34, where in a partition the plaintiff apprays for equitable relief touching the title of the property, the proceeding is to be regarded as a civil action within the meaning of the code. It is generally supposed that partition is a civil action. But unless there is something beyond the mere naked questions of legal title between heirs involved, and no special questions of equity are involved, the question might be doubtful. But it has been so long supposed to be a civil action and appealable that it may not be open to question. Such a view may be founded upon the idea that there is an exercise of equitable powers in any partition case. At any rate, it cannot be classed as an action at law. Sec. 24. Whether the extraordinary remedies are to be considered as a civil action. Quo warranto ad common law was regarded as a quasi-criminal proceeding. The code has divested it of its criminal character, and by the statutory provision creating it as a code remedy has constituted it as a civil action. The statutory provisions as to mandamus have since the enactment of the code been silent on the question whether it is a civil action or not. And the earlier views expressed by the courts were to the effect that it was not to be regarded as a civil action. But it has now been authoritatively settled that it is a civil action. Sec. 25. The question of propriety of abolishing the old actions. Those whose lot it was to devise a plan to abolish the old actions and create the new one to take the place of the old were confronted with an important task. They considered well the step, as is evidenced in the report of the commissioners. The reason and propriety of the adoption of the original common law actions was questioned. It was intimated by good authority that they were contrived to give the entire administration of justice to the patrician order of Rome, to the exclusion of the great body people. It was urged that they depended upon the original writs, and if no original writ existed, no action could be instituted. It was difficult to obtain any distinct and satisfactory account of their original invention. It was observed that as society progressed, as knowledge prevailed, the necessity for speedier and better justice increased. For this reason the actions gradually diminished, one after another being discarded as worthless, cumbersome, and embarrassing. This had reference to the earlier common law, when the common law was comparatively in a crude condition, when the law merchant was but a special custom, when they used a great number of actions. Later, when the law merchant expanded in every direction, growing into a vast science, the law was administered through the medium of not more than 10 actions. The question of practicability of the abolishment of the old actions confronted the framers of the codes. They considered well the change, looking to the defects in the old system, the disadvantages and dangers therein, and the difficulties involved in commencing the wrong action. The embarrassing features of distinction between trespass and case had already been corrected when the common law system was being practiced. This the framers of the code considered as the beginning of the work they undertook to complete. The desire, too, was to abolish all formalities, falsehood and fiction involved in the old system. They could find no good reason for the continuance of the old system. Sec. 26. Opinions of the courts upon the effect of the change in the nature of the action. The first code having been enacted in New York, the decisions of the courts of that state naturally furnished the basis of discussion upon the nature and effect of the change. The nature of the change was readily perceived and expressed by the courts of that state, whose opinions were followed by the courts in the states subsequently adopting codes. It was at once recognized that the code had merely abolished the distinction between the mere forms of action, while the intrinsic differences between the different actions remained untouched. It was readily seen that the codifiers found it impossible, or impracticable, to abolish the substantive distinction between the actions. The ascension principles between the several actions were considered to have been untouched, the innovations or modifications being only as to technicalities and matters of form. This applies to all classes of cases. That is, the distinction between actions in contract and tort, between the different tort actions, and between law and equity, so far as concerns the substantive rights of parties, remains the same under the code as before. So far as concerns the substantive rights of parties, they remain the same under the code as before. The change being one of form only, and not of substance, the same substantive distinction between the different rights and causes of action is observed in code practice as under the old system. Practically the same distinction is observed between trespass and case, and other tort actions, between contract and tort actions, between law and equity cases now, as before the code.